Hello, and welcome to topic number one in our course, Real Estate 617, The Law of Common Interest Communities at John Marshall Law School. This first presentation is about an introduction to the topic, why you should learn about this form of housing as a practicing attorney, the origins and history of it, how they are created, the unique features or attributes of HOA living. We will talk about how and why they have become the predominant form of new residential housing construction in most of the major metropolitan areas in this country. That includes not only the suburbs. People always think, well, they're found in the suburbs, and of course they are, but you'll find them all over redeveloping urban areas and far-flung exurbs out in the boonies. And that is definitely true of Chicago. In Chicago, almost all the housing that has been and is being constructed in the North Loop area, South Loop, West Loop, etc., that new housing is almost all in common interest housing. It is either, in most cases, it is townhouse or condominium home ownership. And out in the suburbs, you find the single-family homes in homeowner associations. And so I'm sure most of you have seen this, but you may not understand how they're constructed and how they work, and we're going to make sure we cover that. These associations are run by private governments, and those private governments are the clients of many attorneys. The homeowner and condominium associations basically function as private governments. And also, I want to stress that this is happening not just in the United States, it is happening all over the world. That in nations on virtually every continent, most of the, or some, most, or in some cases, nearly all of the new housing is in these associations. And we'll talk about why that is happening. So this becomes a really interesting topic for a practicing attorney, I think. So let's first talk about what it is. When we say common interest housing, we also use the term common interest communities, which is in the course title, this course. What we mean is, in most cases, we mean condominium housing, and we'll explain what that means. It's a form of ownership. And also single-family detached homes in subdivisions that have homeowner associations. It also includes housing cooperatives, and we will talk a bit about housing cooperatives and how they differ. So you have three types: condominiums, homeowner association run developments, which is usually single-family detached homes and subdivisions, and housing cooperatives. We have a surprising number of housing cooperatives in the Chicago area. Now, this divided ownership that is referred to in the second bullet point, what we mean here is that when you acquire ownership in a condo or an HOA, you get two different types of ownership in one deed. One is what's called an individual interest, and the other is a common interest. The individual interest, that means the part of the ownership package that is exclusively yours. And I'm going to show you what I mean by that in just a minute. But for example, in a homeowner association, it would be a house and a lot. That's your individual interest. But there's also a common interest, and that means every owner has not only their own individual interest, but they have a percentage or at least partial share in other property that is owned in common with the other residents. And so the deed describes that you, by acquiring the property, you get both these interests. You get your individual interest and also the common interest. And it's the common interest that creates a lot of the complications that we'll be talking about. These subdivisions, all condos, HOA subdivisions, cooperatives, all of them contain what we call private land use controls. That is a set of rules that restrict all the owners or that empower the association. We call them sometimes CC&Rs, or covenants, conditions, and restrictions. But it's really a declaration. It's the more formal term for it is a declaration or a DEC. And along with that go some other governing documents, articles of incorporation, rules and regulations, corporate bylaws, and so forth. And again, we'll be covering that. You also get in common interest housing a private government, which is almost always set up as a not-for-profit corporation. And that corporation collects and spends revenue from all the owners in the form of what we call assessments. And then they establish budgets, annual budgets, and they arrange for the provision of services, the maintenance sometimes of infrastructure, sometimes fairly complicated infrastructure, like water and sewer systems, and the providing of certain types of amenities, recreational amenities, and so forth. So these private governments often need legal representation, and that's where lawyers come in. The other thing to keep in mind about common interest housing is there's almost always a substantial degree of planning. That means that the environment of the subdivision or the condo building has been thought through in advance. It didn't sort of grow up organically. It was built all at once with a plan in mind. And so the association, the private government, is the entity that really enforces the plan. And that plan includes a lifestyle. In some cases, it may include limitations on what types of people can live there. It may provide a whole array of activities, boating, swimming pools, tennis courts, and all sorts of things that were designed in anticipation of people living a certain way. Some subdivisions exclude people below the age of 55. They're age-restricted communities. Others have some fairly elaborate security measures, and these are all designed to attend to the needs or the preferences of the people who live in that particular community. So that's what I mean by planning. Now, there are several different types, as I said, of common interest housing. So let's look at the interests that are involved here and understand how the individual interest, the common interest, and the association function differs in the three types. First, let's take condominium housing. Condominiums involve an individual interest that is actually fictional. The real property individual interest in the condominium is nothing but an airspace. It is the interior of the unit, the air, literally, the airspace, and the finish on the walls and the floors. So the carpeting, that's part of your own individual interest. That's personal to you. The paint on the walls. But anything beyond the paint, anything below the carpeting or the flooring, that's all part of the building. And that is part of the common interest. And so if you go down a notch, you'll see where it says percentage ownership in the entire property minus the airspace units. In a condominium, the entire building, except the airspaces, is owned in common by the unit owners. So each one of them has a percentage ownership, basically, in the whole building. Now, the function of the association in a condo is to manage the building, to manage the common elements, which is basically everything. An HOA is different because in an HOA, the individual interest is quite real. It normally includes a house and a yard. And that's much like conventional single-family home ownership, except that there is also a commonly owned interest. That is, every owner has, in a sense, an interest in the properties that are owned by the HOA, because unlike a condo association, an HOA owns and manages the common elements. And that, what would that be? Well, very commonly it is streets. That is, the streets are owned, they're private streets, they're owned by the association. And the residents have a voting interest in controlling the association that owns the common elements. But it can include much more than just streets. It could be, for example, a lake. It could include walls and gates, parks and other recreational facilities. And many subdivisions out in the exurbs have their own sewer and water systems, and those are owned by the HOA and managed, and that can be quite expensive and quite a responsibility. A housing cooperative, that's the third type, and there's quite a number of those in Chicago. They are interesting. The individual interest is a corporate share. It is essentially a share of stock in the corporation. So that means that the cooperators, the owners, are shareholders in the corporation. The other part of their individual interest is a lease. They get a lease to occupy their unit. We call it a proprietary lease because basically it's as if you owned your unit, but you are in a sense, if you think about it, with a cooperative, um, you are your own landlord because you are a share owner in the corporation that owns the entire property and rents it to the owners. So essentially, you become a percentage interest in being your own landlord. The cooperative owns and manages the entire property, and it is controlled by the shareholders. So those are the three types of common interest housing. We don't see a lot of new cooperatives for a variety of reasons. Developers, even though they've been successful, cooperatives are successful, developers much prefer condominiums. It's much easier to sell the individual units. Cooperatives, we'll talk about this later, but they have more influence over who lives in them, and it complicates the process of selling them. You get one big mortgage on the whole property rather than individual unit mortgages. And so developers prefer to build condominiums as multifamily housing rather than cooperatives. Although, as I said, there are quite a number of them in Chicago. Single family home ownership out in the suburbs, you'll see most of it these days is in some form of HOA. So those are the three forms. Why would you want to take this course and learn about common interest housing? Well, first, I would argue that all real estate transactional attorneys who want to do closings need to understand these various forms of housing and how they operate. When you're requesting disclosure from, let's say you're representing a buyer, you're requesting disclosure from the seller. Well, you need to know you should also be asking for disclosure, not just from the seller, but from the condo association or the HOA. And you need to be able to inform your client about the finances of the association so they don't end up buying a home that leads them into immediate financial difficulties. You need to know about the rules and be able to read the declarations and so forth so you can understand whether your client may have needs or hobbies or other activities that might bring them into conflict with the association. Secondly, any litigation attorney who's involved with real estate needs to know about the types of litigation that we find in associations because there is quite a lot of it. Assessment collection, that is the collection of assessments from the owners, their dues. This is a very lucrative area for lawyers because the association has a lien on the unit to pay delinquent assessments, and it's actually provided for by statute, so it's a really good way to get paid. Covenant enforcement, that is enforcing the rules and regulations. Construction defect litigation against developers and other types of litigation. And so if you understand how these associations are involved, you may be able to do a much better job of handling litigation of this type. And also there are firms that do nothing but represent associations. They are the general counsel, so to speak, for associations. And it's a field in which a number of fairly large firms in the Chicago area do a lot of this. And there are small firms who get HOA business as well. So that's the sort of general counsel thing. You advise them on how to redraft their covenants, how to handle issues that come up. And so all told, though, this is quite a complex and interesting area of law that brings together the law of contracts, the laws of real property, sometimes local government law, and very much the law that governs not-for-profit corporations. So it's an interesting, complex, and growing area of law. So let's turn to the origins and history of this type of housing. As I said, I've written a couple of books. These are the covers of the books. And I'm at work on another book right now, and I've written many articles on this. And so I've spent quite a bit of time studying where these associations came from. I think you will find it helpful to understand this. So let's take a look at that, shall we? The current incarnation of associations that we see in the United States dates back to the mid-1900s. There was a period in which landscape architects like Alexander Jackson Davis, Frederick Law Olmsted were constructing really beautiful, what were then called romantic suburbs. In other words, they were planning and designing communities, not just houses. They were not just designing one house and then someone else would design a house next to it and a community would grow organically. They came up with the idea of starting in undeveloped land and planning entire communities. And one of the earliest was Llewellyn Park in New Jersey, and you can see this old layout drawing that goes way back. This was in Orange, New Jersey, and it is a type of community that was very popular with affluent people. This is before the mass suburbanization of America. Then the famous landscape architect Frederick Law Olmsted, who really is credited by many with sort of founding urban planning in the United States of America. He did similar things. He designed romantic sites. And one of them is Riverside, Illinois. And you may be familiar with Riverside. It is out in the western suburbs. And he designed it, planned it in 1868 through 1870. And it is a model for the planned communities that followed. And it was very important in particular to one individual, a man by the name of Ebenezer Howard. He was an English court reporter who was really appalled by living conditions in London. He lived in London and he hated it. And as it happened, he came to the United States. He was in Chicago, as a matter of fact, and undoubtedly saw Riverside. And he was influenced by Olmsted and by other things he had seen. He saw that in the United States, planned communities of the type I just described were coming into existence, and he was fascinated with the idea because there was nothing like that in England. And so he came up with the idea of the Garden City. He said that, London is ugly, it is too big, it is smoky and polluted, there's too much crime, it's an unhealthy environment. And then he said, in the countryside, that's too boring. So, there's nothing going on except people herding cows and so forth. So he thought, what would be perfect is to combine city and country in one planned subdivision, we'd call it today. He called it a city, the Garden City, a new city constructed in undeveloped land out in what we would call the exurbs, and connected to other planned cities by railroads and highways, roads. And so you see here the original Garden City model, which shows a park in the center, houses and gardens around it in rings, streets crossing it, boulevards, and then in the outskirts, in 5,000 acres of agricultural land, it would have an agricultural college and cow pastures, etc. In other words, it would be a completely self-contained, newly developed city built from nothing, a planned city that was actually a utopian city, a city that would bring out the best in everybody and be the ideal form of human habitation. So here you see a close-up of one wedge, and you can see how carefully this was planned and laid out with railroads and boulevards and shopping and so forth, and farm agricultural land. So these cities were supposed to be self-contained. People could live and work there. And he felt that they would be so desirable that, as he put it, London must die and a new city rise on the ashes of the old. He envisioned these planned cities completely replacing the existing cities. And then they would be connected to each other as what he called social cities. They would be connected to each other by roads and railways, so that you'd have a network of planned communities that would be communicating with each other, and nobody would need to go to London anymore. Now, this is interesting because if you look at what's happening with the exurban ring in Chicago and other major cities, there's been a lot written about this, about people commuting from one exurban community to another, and how that begins to look a little bit like what Howard was discussing, doesn't it? Where people go from Schaumburg to Orland Park or something, Lake County to Will County, and don't really need to use the city. And there are such people. Of course, it hasn't really gone that far. I mean, Chicago is still alive and well, but there's certainly a thriving exurban and suburban ring that is, to some extent, increasingly independent of big cities. So when Ebenezer Howard's model came to the United States, it was actually a movement called the Garden City Movement. And their idea was different here. That is, American developers looked at utopia differently. They'd say, well, Howard envisioned having a real city, that is, a municipality. American planners envisioned private development, private communities, not cities, not municipalities. In fact, they wanted to build in unincorporated land where there was no existing municipality, so they would not have to worry about city government at all. They didn't want to have poor people, and as Howard envisioned, they wanted affluent residents who could afford to buy homes. The type of government was not a municipality, as he envisioned. It is a homeowner association. And they wanted to do this through private lawmaking, through restrictive covenants, private contractual agreements, including race-restrictive covenants. That is, early American developers almost universally imposed racial restrictions on the housing, and those became unenforceable after the Supreme Court's decision in Shelley versus Kramer in 1948, but they really did have a tremendous amount of influence on the segregation that we see around us in Chicago and other major cities. Also, a big difference here is that in the United States, there usually has not been a serious attempt to create communities where people work. That is, almost all American Garden City copies do not have employment in them. And so that is a major difference. They are, to some extent, bedroom communities. There are some exceptions, but in most of them, there's no substantial employment base. The first American Garden City was Radburn, New Jersey, developed in 1928. Very influential because the type of government that they created for it is the model for what we have today. And we're going to be studying that in some detail in the next PowerPoint. We'll be talking a lot about this. But what homeowner association government looks like. It was really developed at Radburn in 1928. It was designed by some of the most prominent political scientists and public administration scholars in the country as a model form that is intended to be a private version of the city manager model. The city manager model is in use in many suburbs around the Chicago area and around the country, and we'll talk about how that works. But basically you have an elected board of directors in a condominium or HOA who have a president, but the day-to-day management is usually carried out by a professional manager. Now in a city, that would be a city manager. In a condo or an HOA, it's a property manager. And we have all kinds of these firms around now hiring themselves out to manage common interest communities. Smaller associations often can't afford professional management, so they have to self-manage, which carries a whole set of risks, but we'll be talking about that. The Urban Land Institute was founded originally by Jesse Clyde Nichols, a large-scale developer who laid out the Country Club District in Kansas City. And he loved HOAs, and he hated cities. And so he took this to a slightly different level. That is, he began the process in the Urban Land Institute of standardizing how to do this, standardizing how to create private communities. He wrote articles about it. And later, the federal housing began to get heavily involved in housing construction after their creation. I believe it was 1935, the FHA was created. After World War II, there was a massive wave of housing construction because there had been very little construction from 1929 when the Depression started through 1946 or 1945 when the war ended. So in 1946, there was a huge pent-up demand for housing construction. Well, a lot of land got gobbled up in a hurry, and eventually developers, because of the rising cost of land, began to turn to old ideas, such as the Garden City model, the Radburn model, cluster subdivisions, and so forth. And FHA and the Urban Land Institute began to promote common interest housing development in the early 1960s. They arranged for Congress to and the FHA to provide mortgage insurance for condominium and HOA units, and that helped to really start the market, and developers began to build them. They could get more people on less land and sell a competitively priced housing unit to people. From 1978 to the present, tax resistance, the property tax revolt across the country, began to hit municipalities. And this is very significant because now you had a couple of things going on here. One is developers are saying, well, we're being told we shouldn't help create sprawl, which means putting all sorts of people in big lots. And secondly, land is getting very expensive. And so big lot subdivisions became very expensive. And so developers were looking for ways to put more people on less land. At the same time, municipalities, and this really took off around 1978, were saying, well, that they were in a bind. That on the one hand, here we have the developers who are looking at increased land prices and saying they don't want to see their housing units go so far up in price that middle-class people can't afford them. And so how do we get more people on smaller lots? And the municipalities are thinking, well, wait a minute, how do we have any construction? Because we can't afford to build streets. We can't afford to build new infrastructure, schools, parks, water and sewer systems, etc., because our local residents don't want their taxes increased. And so in many cases, there were state laws put in place that prohibited property tax increases. We call those TELs, tax and expenditure limitations. And so what began to happen here was cities and developers began to see that they could use common interest housing as a way to get around both these problems. Common interest housing with the commonly owned amenities allowed them to get more people on less land. You don't need big lots. You don't need swimming pools in every yard if you have a commonly owned swimming pool. And cities are saying, well, we can make these people build private streets. We don't have to build the streets. We can make them build private parks. We say we won't give you a building permit unless you build private parks and private recreational facilities and your own bike paths, etc. And then the cities have a property tax windfall. They get more people, more property taxpayers, more property tax revenues without having to build and provide the same level of services and without having to build all that infrastructure. So they're getting a tax windfall. They're getting something for nothing. Increased tax revenues without increased costs. And so developers and municipalities really saw this as mutually beneficial. Now, what about the third leg of the triangle, the consumers? Well, some consumers, well, most really don't understand this type of housing. That's why they need lawyers. They don't understand how it works. But in many cases, consumers like the idea of privacy, control, a greater sense of security, private communities, their own government, their own property, the ability to exclude outsiders. And they kind of like that. Some consumers do. And so all these trends began to converge, and it caused a tremendous boom in housing. And I'm going to revisit that and give you some numbers on that in just a couple of minutes here. But first, let's talk about how they are created. Step one is the developers acquire property. Step two is they subdivide it. They create new lots with a development plan. And that's true whether it's a condo and the property is vertical, or whether it's a conventional HOA and you're just cutting up agricultural land into building lots. They then draft and record the governing documents, and they record them. It's important to understand these documents are recorded against every lot before anyone ever buys it. The developers do all this while they own all the property. A declaration of covenants, conditions, and restrictions, articles of incorporation, corporate bylaws, rules and regulations, all recorded, all set up so they attach to every single lot in the subdivision. Then, after all that's done, then they sell their units. So everybody who buys a lot is bound by all the developers' previous actions. And so we have what follows is a period of developer control we sometimes call declarant control, where the association is controlled by the developer entirely. And then that period phases out and the association and control over the association is gradually turned over to the owners. And in Illinois, that's supposed to take place in no longer than 3 years, and sometimes it doesn't, even though it's supposed to. But there are different ways to do this in different states, but the idea is the developer must relinquish control over the association to the owners eventually, which of course they want to do. The developers don't want to control it forever. They do want to control it while they're selling units, though. Now, let's talk for a bit about the unique features of HOA living. First, we have shared ownership. I mentioned that you have the individual ownership and the shared ownership, the two parts of the package. And this creates an economic situation of interdependence with the other owners that is unfamiliar to most people. And also going along with that is a lack of the sense that most Americans have that when they become homeowners, they get dominion and control over their property. My home is my castle. That's not the way it works in common interest housing. It's not that way. But people sometimes act as if it were that way, and it causes a lot of problems. Because you really have to accept that the neighbors have some authority over you. The ones who are elected to the board of directors are a little private government, and they can restrict your activities in conformance with the governing documents. And so you need to know the documents and you need to follow them, because you can get into a lot of trouble if you don't. I mean, many people think these governments don't have teeth, but they certainly do. And so they can restrict certain activities. They can also, and typically do, require a higher standard of property maintenance than you might find in surrounding non-covenanted communities. However, you have to understand, and I think attorneys should always tell their clients this, the association runs on volunteers. It has elections, and that means that when you live there, you have to pay attention to the private government. You have to be prepared potentially to serve, or at least to participate, to go to meetings, to understand what's going on, to vote intelligently, because this is your money, it's your lifestyle, it's your property to some extent. You also have to understand, the owners, that they get two essentially tax bills. I mean, they're going to pay property taxes, but they're also going to have to pay assessments either monthly, semi-annually, or annually. And they can be substantial. Especially in an urban condo, you might pay, $300, $400, $500, $600 a month to your association, and you're also going to pay property taxes. Now, you get something for it. You get something for your taxes, and you get something for your condo assessments or your HOA assessments. But understand, you're paying twice. And this is, lastly, a very, very important thing. Owners bear a risk of financial loss that the rest of us don't have. That is, they may have to pay the obligations of the association. If the association decides to undertake a major building project, if the association gets sued and has to pay a judgment, the owners may be liable to pay off those judgments or those obligations. And they may not want to. You may get hit with a special assessment, $20,000 per unit to put a new roof on the building. If the association doesn't have the money, can't get it any other way, they may just hit you with a special assessment. So people have to understand these are unique features of HOA living. And, you might say, well, anyone might have to put a roof on their house. Yeah, that's true, but you can make the decision when to put the roof on. And when you live in a condo building, the board will make the decision, and you'll have to come up with the money. And so this is something that needs to be kept in mind. Now, to return to this, I was going to mention that I was going to address how these have become the predominant form of new housing construction. And I explained a bit about that, so let's go back and go through it step by step and look at some of the numbers so you understand why this is a growth area of law for the future. First, these are just a couple of diagrams. I found a colored version of the Garden City model. It's kind of an interesting one. You can take a look at it. You can see some of it clearly. I think it's interesting. You see where it provides for an insane asylum. And if you've ever worked or lived in a condo or HOA, you may see the need for an insane asylum. But in any event, let's address some of the. First, here's some data. If you go back to 1960, FHA and the Urban Land Institute did a survey. They found about 250 common interest communities. So they figured they didn't get them all. So they doubled it and said, we think there are about 500. And I know that because I interviewed the man who did the survey many years ago. So I know how they did it. They said there were fewer than 500. What they really found was about 250. And Once FHA began to certify them for mortgage insurance, they began to take off like crazy. So you see, by 1970, there were 10,000. 1980, 36,000. And then, boom, it exploded. And in the 1980s, it basically quadrupled and then nearly doubled again in the next 20, 25 years. And so by today, 2015, 2016, 2017, it's somewhere around 340,000 communities housing an estimated 26 million people. 26 million housing units and 68 million people. So we're talking about approximately, roughly speaking, 20% of the housing units in the country and over 20% of the population that lives in these communities. And if you look just at the new housing stock, just new housing each year, you'd see it's by far the majority of new housing almost everywhere. HOAs are over half of the total, and condos about 42 to 45%, cooperatives maybe 3 or 4%. And here's a graph that just simply shows the rapid increase during the 80s, 90s, and 2000s of this type of housing. This is some other data. This refers to housing by year, because this supports what I said earlier about what's the new housing stock is where you see tremendous numbers of a tremendously high percentage of HOAs and condos. So let's take the year 2015. If you look at the year 2015, 71% of the new housing, the new single-family housing sold, 71% of it was in an HOA. 2009, it was only 62%. So it is the majority of new housing construction, and it is a growing share. And you can expect this to continue. I mean, I've been saying this was the case since 1985 was the first article I wrote on this. And I've been tracking it as best I can using available data, which are not ideal, but it's been obvious to me from the 1980s on that this is the future of housing construction, and it's not going to go away anytime soon. Now, some states have more than others. Florida, in this case, I have ranked the states by the percentage of their housing that is in common interest housing. So, for example, if we take Florida, you find 47,000 common interest housing developments with a population of 8 million in a state that has 18.8 million. So you see 42% of the people in Florida live in these associations. Coming down to Illinois, we have an estimated 18,000. Now, by the way, that is the Community Associations Institute's estimate. There is another estimate that puts it at 30,000, and that's by a private real estate analyst. And nobody really knows for sure because we don't have an actual state registry in Illinois, and so it's a little bit difficult to say for sure. But we know there are at least 18,000 of these developments in Illinois, housing about 23% of the state population. So almost a quarter of Illinois residents live in common interest communities. Why? Well, I explained this. And I've studied this actually using the available data in the state of California as an example. And as I said, part of this is supply and demand, or a large part of it is. First, developers want to increase residential density where good land for development is scarce and expensive. They don't want a price to sell houses that nobody can afford to buy, so they try to make the lots smaller. Local government fiscal capacity. They want that double taxation because they want to grow and increase their revenues, but they can't afford to do what they used to do. They can't afford to build the streets and the roads and the infrastructure. So they use the subdivisions run by HOAs and built by developers as a way to get private infrastructure. And so the people who live in them are doubly taxed. They don't often realize this is what's happening, but they are. They're paying their property taxes, and they get a lower level of services because they have to pay for their own this and their own that. And then I mentioned on the demand side, you see the consumer preferences. My study showed that 2/3 of the variation in the number of common interest communities by county is explained entirely by land prices and local government fiscal capacity. So I think those are the major factors. But we can't forget the politics of this. That is, the rapid spread of CIDs was driven heavily by incentives, and those incentives definitely included not just the rising land costs, but the tax resistance that was generated in the public by the property tax revolt movement across the country. But what this all happened so fast that is the CIDs spread so fast that there was really no public policy framework to support the private governments institutionally, to oversee them. That is only now being put in place. So these little private governments are reliant on attorneys and property managers to a substantial extent because there's hardly any government support for anything they do. And this is a bit of a problem. And it's, as an attorney in this field, it may be good for you for the time being, and it may also be something you might want to get involved with, that is on the legislative front, because this is an active arena for legislation. So this represents ultimately a massive privatization of local government services and local government functions. So look at what associations do that governments used to do and still do, but aren't doing for these residents. Budgeting, taxing and spending for the general welfare, taking care of streets and roads, providing water and sewer in many cases, recreation facilities, including often big lakes, recreation facilities, parks, etc. Land use control, telling people whether they can build a house on their own property or not. That's one thing many associations are able to do. And what kind of fence you can put up, etc. And behavioral regulations. Can you have a gas grill or a charcoal grill? Can you have a ham radio antenna? Can you build a handicapped ramp or not? And where? Flag poles, military flags, etc., etc. All sorts of things like this. These used to be government functions, and now citizens are performing them, and they often need legal advice on how to do it. And that's what the private governments are about, the associations themselves. So a large part of the course is about how these associations operate. And so we'll talk about their powers, their duties and obligations, the limits on their powers, the state regulatory apparatus, such as it is, that creates a framework within which they operate. A lot of the practical considerations that go into the life of the lawyer who practices in this field, and how to deal with certain common issues. We have presentations of some of these things, like how to amend the documents. Very critical issue. The documents have to be amended from time to time. How to deal with requests for architectural modifications, elections, assessments, budgeting, litigation, financing. So we'll be talking about a lot of those issues. Understand that as of today, we have, as I said, over 20% of the population living in these developments. The property's worth at least $5 trillion. That's the level of the responsibility that these associations have. Over 2 million volunteers. They collected at least in a given year, they'll collect at least $85 billion in assessments. And they have another at least $23 billion in reserve accounts. So you're looking at, this is a $100 billion industry in terms of the revenues, and a $5 trillion industry in terms of the property values. So there's a lot of money and a lot of people involved in this. Now, I mentioned that it's complex, and it is. Let's go from top to bottom here. The sources of the powers and the limits on their powers, what are we going to be looking at? Well, first of all, we won't spend a lot of time on this, but it's important to know. There are very few federal regulatory statutes involved here. There's a few statutes on satellite dishes and flags and so forth, but federal law that is related to common interest communities mainly pertains to the agencies, Fannie Mae, etc., the FHA, the government-sponsored entities, the GSEs. They have requirements about the standards for the issuance of mortgage insurance and for the purchase and sale of mortgages in the secondary mortgage market. And those requirements create standardization in the industry for governing documents and rule provisions. And so we're definitely going to be covering a lot of that. But understand the GSEs are behind the scenes. They're not directly regulating, but their standards are very, very important because if people want to be able to sell their house, you live in an HOA, you want to be able to sell your house, you have to be concerned that it will that your association will qualify under, let's say, Fannie Mae guidelines, in order that the mortgage that your prospective buyer takes out can be sold on the secondary market. And if it can't be, then that's a real problem. I mean, banks don't like to lend money to people if they can't sell the mortgage on the secondary market. And so, unless you're just going to go for cash buyers, you have to make sure that your association complies with the standards of Fannie Mae. Secondly, and this is very important, state statutory law that governs all not-for-profit corporations. So typically in your state corporations code, you've got provisions that govern all not-for-profit corporations and maybe all corporations. And so you have to be familiar with that because it's a corporation. And then we have the special state laws that govern condos and or HOAs. Every state has a Condominium Property Act. Other states have, such as Illinois, have a special act for homeowner associations, a Common Interest Community Association Act. But the point is, there is special state law that just governs common interest communities. And then we have, next you have to consider the governing documents of the particular development you're dealing with. Never answer a question about an association unless you've read the documents. That's their own private laws that cover that development. So that means the declaration, very important. The articles of incorporation, usually that you don't have to read that, but they do exist. The bylaws that were usually, it depends, they're often part of the deck or they may be separate. And then additional rules and regulations for architectural modifications and other things. And then you have to know the judge-made case law, the interpretation of the statutes. And most of this is in state courts. I can't say all of it. There are occasions where you'll find federal cases that are relevant to this. With respect to the judge-made case law, final note, you need to begin with state laws in most cases. Begin with the Condominium Property Act, begin with the Common Interest Community Association Act in the case of Illinois, and then look to the way particular document provisions and state law have been interpreted by the cases. But always I begin with the statutes and the governing documents as a general rule. Now this is very important. Where do these associations get their money from? And I mentioned assessments. It all comes from the owners. Regular assessments are supposed to cover operating assessments and a contribution to reserves. This is absolutely critical. Today's members control their own assessments. They decide by choosing a board of directors and the board making decisions. They decide how much they're going to set aside for future repairs, and they almost always don't set aside enough money. Almost all associations are under-reserved, and this is a real problem because when the association discovers they have to put on a new roof, they don't have enough money to do it. So this is where special assessments come in. And they can be very burdensome. Often they can cause people to go into foreclosure because associations understand if you don't pay the assessments, the association can foreclose and sell your unit to get their share of the money from you. They can foreclose on you just the same as the bank. And many people are foreclosed on by their associations if they don't pay these special assessments. That's their only recourse. Often associations have no investment income, very few, if it's maybe very little in the form of CDs or something. Some associations have special fees or charges if they own a golf course or a lake or something, but most associations don't. Now, what about loans from banks? Well, we'll talk more about this later, but understand banks will lend to associations, but it's difficult. And the loan will be secured by the assessment stream, meaning the bank, if the association misses a payment, the bank can take over and have the residents pay their assessments directly to the bank. So this is serious business. Insurance, well, that covers sudden and accidental losses. It does not cover repairing and replacing major building components that just wore out. And litigation, well, if you have defects in original construction, you may be able to sue the developer, but it's hard to do in the state of Illinois. It's not an easy thing. It can be done. It can be done once if necessary, but it's not going to do you any good if you're outside the statute of limitations. And last point, understand this type of housing is appearing all over the world. Here's a couple of recent books. I have a chapter in the one on the left there. It's a comparative look at HOAs around the world. And then over here on the right, you see a book written by a friend of mine, Cornelius van der Merwe, who is a law professor in South Africa. He's done a big treatise on European condominium law, comparing the condo laws of all the nations of Europe. So this just gives you a sense for what's going on. They're all over the world. You can find them in Europe, all the nations of Europe, Asia. China has an estimated 250 million people living in common interest communities. Canada, Latin America, particularly Brazil, Chile, some of the other large urbanized nations of Latin America, Australia and New Zealand, and the nations of Africa, certainly Northern Africa and the Middle East, and to some extent Sub-Saharan Africa as well. Now, why is this? Well, one explanation says that an American model has been successfully and aggressively exported by the Urban Land Institute and the Community Associations Institute and other organizations that they've tried to expand the market of American developers and consultants overseas. That's one explanation. Another explanation is that they have similar conditions in these countries. That is what we talked about, urbanized areas that are growing fast, where the demand for new housing outpaces the capacity of local governments to build the infrastructure and provide the services for all the new residents. That's what happened in the U.S., and it may be happening in other countries as well. It certainly does appear to be happening in other countries. And in essence, what I would argue is you have both. In other words, both you have the similar conditions and you also have an American model ready at hand.